First District Court of Appeals is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have one case on our oral argument docket this morning. Case number 24-2098, SEI Fuel Services versus State of Florida Department of Revenue. Mr. Bowen, you may proceed.
Good morning. May it please the court, Michael Bowen for the appellant, SEI Fuel Services, Inc. Your Honor, Section 213.255 Florida statutes outlines the conditions by which a taxpayer is entitled to interest on overpayments of tax. The statute states that interest shall be paid on overpayments of taxes subject to certain express conditions. Now, that statute has three critical subsections that are of importance to this case.
Before you get into those, would you like to reserve any time for rebuttal?
I apologize, 5 minutes.
5 minutes, thank you.
Subsection 2 of the statute states that the refund application must be complete, and it gives 5 requirements for a complete refund claim. Subsection 3 states that the Department of Revenue shall examine the refund claim within 30 days and make a determination as to whether that refund claim is complete or whether additional information is needed to verify the claim. Now, the refund claim is complete as of the date that all the conditions are met. Subsection 4.
So they're saying that there was no finding by the ALJ that the application was complete.
Correct, Judge Roberts, but 213.255 tells us when the refund claim is complete.
Okay.
Not the ALJ, not this court.
Well, they also said that you were required to prove it was complete, and you didn't come forward with any evidence that it was complete.
We weren't required. 213.255 tells us if it's complete.
Sure.
And the department acknowledges it was complete. I know this for 2 reasons. One,
and it seems to me that they can't be arguing that here. You know, this court awarded the refund, said that the refund should have been done. So arguably, it was complete, right?
100% correct, Judge Roberts.
Well, not only that, but they also gave, on their own accord, $500,000 of refund, right?
Wow, you guys are arguing for me.
So
correct.
It would seem like the way that
We won't do this the whole time.
that the way that they contest these cases, that they're not going to give you $500,000 if your application isn't.
That is our argument, is that they knew it was complete. Otherwise, they wouldn't have issued us $555,000 before we even filed suit in DOA, and they wouldn't have issued us over $3 million of tax refund after this case was decided if they didn't think the refund claim was complete.
It seems to me that the argument they put forward that has some merit, maybe, arguably has merit, is that mandamus was not the right remedy. So would you talk about that?
It wasn't the right remedy?
Yeah. That mandamus doesn't lie because there was a, you know, they could have achieved a remedy through law, you know.
Could have achieved
one of the prongs of mandamus is you can't have an adequate remedy at law.
Oh, sure.
They're saying that you had an adequate remedy at law.
We, of course, say we did not.
Okay.
When this
Yeah.
court,
Well, tell me about it.
when this court issued its decision on February 14th, 2024, the refund check had not been written, had not been paid. March 4th, when this court issued its mandate, had not been paid. The refund was not actually paid until 38 days later, on April 11th, 2024. They issued us a check for the tax. We reached out and said, where's our interest? They said, pound sand. We're not paying interest. We tried to work it out. It didn't work. At that point, Your Honor, there's nowhere else for us to go.
They were arguing that, but they argued that you should have pled your entitlement to interest. What do you say?
This goes back to our original point. 213.255 tells us what a complete refund claim is. We didn't need to plead interest.
Okay.
It was by operation of law.
Didn't you bring up, when you first went to 120 proceeding, didn't you mention interest there?
The amended DOA petition and on remand to the department from DOA, we did state in our prayer for relief plus statutory interest. That doesn't mean we had to. As a matter of course, we often include that in our pleadings. We didn't have to do that. That's our position.
Isn't that kind of odd to consider an interest-oriented dispute sort of ancillary, not even worthy of bringing to the surface when we've got a whole statute, 213-255, but then 72011 that talks particularly about interest being its own important thing worthy of having all sorts of process as to how you bring these claims, where you can bring them, where you can't bring them, and that kind of thing. I mean, it doesn't seem like interest is purely ancillary. It's actually teed up in statutes as being something that's an important focus of some litigation.
And it can be in assessments, right? I mean, because assessments, interest accrues on assessments. You could dispute, and in fairness, Your Honor, if you're challenging a refund or an assessment, you are challenging interest in some respects. Why? Because the interest is based on the amount of the assessment and the amount of the refund. So it makes sense that 72011 refers to being able to proceed jurisdictionally on interest, because when you're challenging the tax or the refund, you're actually challenging the interest.
I've got a more procedural question for you here. I'm looking at, excuse me, the order dismissing your mandamus petition, and it pretty clearly indicates that the circuit court does not have jurisdiction to hear this petition. Doesn't have jurisdiction because the correct jurisdiction is administrative. It then goes on to say, not alternatively, not as, you know, even if I had jurisdiction, I would make this. It just says simply, moreover, there is no right to mandamus anyway. So what do we make of that? If the court has said that they don't have jurisdiction to hear the case, and they don't even make a finding that even if we did, this is the decision we make, did she make any decision at all with regard to whether mandamus was appropriate or not? And if not, what do we do about it?
We don't. Your point is well taken. I felt the same way when I read the decision. It seems to me that the proper forum for writ of mandamus is circuit court. And then the question just becomes whether you meet the three requirements for the writ of mandamus. And we simply argued that we met the three requirements. I'm not sure why the circuit court would argue that it didn't have jurisdiction, other than to say they would have argued, as the department has argued in the case, that this should have been part of the first action. You went to DOA first under Chapter 120. You should have stayed. That should have been where you raised it. And our argument, again, to come full circle, is we didn't need to raise it. It was complete before we even filed, and the department knew that, or they wouldn't have issued us a check before we even went to DOA. If the refund claim was not complete, they wouldn't have issued us another $3 million after the first case was decided. So the refund claim was complete. How do we know it was complete? Section 213.255, the legislature told us what requirements are necessary for a complete refund claim. So to your other point, Judge Winokur, so what we're supposed to do about it, at the end of the day, what we would ask is that this court reverse the order.
Reverse for what?
Because there's two points. There's a motion to dismiss, which was granted. So you have to reverse the motion to dismiss. We would also ask that this court instruct the lower court to enter writ of mandamus in favor of SEI Fuel. Why? Because there's no issue that the refund claim was complete.
But is there anything for us to review if the court didn't have jurisdiction to ever consider mandamus? I guess that's kind of that distills my point.
I'm not sure I understand your question. I do apologize.
So
That's okay.
you're arguing that she was incorrect when she said she didn't have jurisdiction. She had jurisdiction, and she should have ruled in your favor, is your argument.
Correct.
Okay.
Oh, I'm sorry.
That's fine.
If that's as simple as it was, then I apologize.
And what's the basis for the jurisdiction, particularly given that 7201 says you're either going the administrative route or you're going the circuit court route? You can't do both.
Well, the first route was closed off as of March 4th, 2024, when this court issued its mandate. The case was done. The first case was over. There was no ability for us, even if we had to raise the interest, we don't think we had to raise the interest issue in the first case, because interest follows the refund. So we don't believe we needed to raise it then.
It talks about relating to the same subject matter. I mean,
This is a different matter. This is the writ of mandamus based on the department's failure to issue us interest on our refund. That was not a dispute. That was not an issue in dispute. And the facts related to that issue were not involved in the first case. The facts related to the writ of mandamus are pretty simple. On April 11th, 2024, they cut us a check without interest. That's it.
So your argument is you had no way of anticipating that they weren't going to follow 213.255. You had no way of knowing that they would say no to the interest.
Nor did DOA, nor did this court.
And it was not ripe for adjudication until such time that they refused, right?
Correct. Our right to file a writ mandamus did not accrue, did not become ripe until April 11th, 2024. And one of the things that comes up is, well, what could this court have done about it? Could this court have issued an award of interest? Well, how would you do that? You don't know how much the interest is going to be. I don't know how much it is. They don't know until they actually cut the check, because the statute says interest runs until paid. So you don't know what that interest is going to be. Could you have issued an order that said plus statutory interest? I suppose, but that's not necessary, because by operation of law, we're entitled to interest, and the refund claim was complete. We know that's complete, again, because as Justice Roberts mentioned earlier, there's already been two payments, well, there will have been, two payments of tax at that point. The refund claim was definitely complete, or they wouldn't have cut us on the whole almost $4 million.
So if we reverse and remand back to Judge Dempsey to enter the writ, I think the amount is probably still undetermined. You have
Oh,
an
it's
amount,
determined.
you have an amount in your brief, but certainly the day that you filed the application, because they didn't respond within 30 days and tell you you were incomplete, that's the start date. But we don't know, at least I couldn't see in the record anywhere when the voucher was sent over to have the check cut. So it might be
Yeah.
days, might be a week's worth of interest that.
They know.
Yeah?
Yeah, they know. They
Yeah.
know exactly
Well,
what.
I mean,
yeah.
it's easily discernible, but I
It's
think.
easily
Judge-
discernible.
I think Judge Dempsey will have to take evidence and rule on that.
It's a ministerial act
Yeah.
that they need to calculate, what the amount of the interest is and stroke that check.
Yeah.
Thank you, Your Honor. I'll reserve the rest of my time.
Thank you. Mr. Shramsky?
Good morning. May it please the court. My name is
Mr.
Yasser.
Stramsky, I was a little surprised when I saw that you were arguing the case, because this case was set for argument a month ago.
Yes.
And we received a motion from Ms. Dinker saying that I think she had two cases that day, and so we granted the motion to move this, and now you're arguing it?
Yes, Your Honor.
I'm a little confused by that.
Yes, Your Honor. I was brought in after that conflict came up to argue this case.
So we didn't need to continue the case. You could have done it then, right?
No, Your Honor. At that point, I was not identified as the attorney or expecting to argue this case.
Okay, go ahead with your argument. I was just a little confused about that.
Thank you. Along with my co-counsel, Senior Assistant Attorney General Randy Dincher, I represent the department. I want to address one point first that I heard counsel make, which is that the interest claim did not have to be raised in the initial administrative proceeding. And I think that's wrong for a number of reasons, but it's also flipping the standard, right? To satisfy mandamus, SCI Fuels has to show not only that it didn't have to raise that claim, but that it was not able to or not permitted to. And that's absolutely false. In fact, the notice of decision that the department issued, the final determination on the assessment, which denied the refund claim that was at issue in the initial proceeding, expressly denied the interest claim. There's nothing in statute that would provide that an interest claim has to be brought
Well,
as
of
a
course, the
separate-
interest claim would be denied because y'all said y'all didn't know anything. You can't owe whatever percentage interest on zero. That's zero. That's
Of course.
math.
Yes, Your Honor. But there are additional criteria that have to be met for interest to ever be awarded, right? So none of those were tried, none of
What
those were
criteria are
pled.
those?
Well, an application has to be filed within the statute or within the time frame provided within 21526. So there are tolling provisions that apply for audits for the department to process refund claims, but the interest statute is more narrow. There's also a provision that
Well, it
provides.
seems like that should have been an argument in the first case, that, they didn't have a complete application, so first ECA, you shouldn't award them the money. I wasn't on that panel, but my understanding, that was not your argument. And even if it was, this court ruled that they were entitled to the refund. So arguably, a decision was made, at least by this court, that the application was complete.
That goes to the completeness of the application, but there are other criteria. There's the question about whether or not interest even applies in a case where the refund claim arises out of the audit assessment as opposed to a standalone refund claim. So here, the refund claim, and this is not in the record because the record on the mandamus
Interest shall be
proceeding-
paid on overpayment of taxes. It has the criteria. Within 30 days after the receipt of the application, department shall examine the application and notify the applicant of any apparent errors.
Yes, Your
An
Honor.
application shall be considered complete upon receipt of all requested information and correction of any error or omission. And y'all didn't argue that there were errors or omissions that said they couldn't get refund. Y'all's argument was they the tax that was paid by Sunshine Gasoline was done by the wrong method, and the correct tax was the tax they paid, so they can't get that back, and Sunshine Gasoline is another section, so they can't get that either.
Right, Your Honor. So the department certainly argued that there was no legal entitlement to the refund, but the burden on any claimant of interest in any proceeding, the burden on any claimant is to establish the claim. So it wasn't the department's burden to disprove the
So
right
in
to interest. But I want to address
223284, didn't this court sub silentio find the application complete?
I don't think that's necessarily true, Your Honor. But I want to address this.
So we ordered you to pay three and some odd $1 million on an application that wasn't complete, is what we did.
Well, there were stipulations that basically circumvented the question of whether or not the application was complete, stipulations with respect to who paid which payment. And that doesn't go to what was in the application itself. But I want to address some other points within the statute here in 213-255. Again, the refund application must be filed within the time period in 215-26. There's no tolling provision in the interest statute. 215-26 establishes a 3-year statute of non-claim for filing a refund claim. Now, while that period is tolled for granting refund applications, it's not, and there are tolling provisions that specifically address tolling in other contexts within 213. There is no tolling for interest in 213-255, but perhaps more significantly, if you look at subsection 4, because the completeness of the application is not the only trigger, or not the only prerequisite for an interest claim. In subsection 4 also, if there's any agreement between the parties that a verification or an audit of the claim is required, then interest doesn't toll until, or excuse me, interest doesn't apply until that verification is complete. And here, there was an informal protest filed by SCI Fuels disputing initially the notice of proposed assessment, which denied the refund claim, which was even before the notice of decision. There was an understanding, at least to our view, that the refund claim would have to be verified, and that wasn't done because the department was taking the position of, among other things, that as a matter of law, this refund wasn't due. The verification wasn't complete
Yeah, and
until
this
there
court
was a
told you it
determination.
was and made you pay.
And that's when the verification happened, because of the interpretation of the statute. But I would note, in the prior proceeding, in the administrative proceeding before the ALJ and DOA in 2021, the case had to be continued because SCI Fuels came prepared with no evidence. Again, in 2022, the case was continued because there was no evidence at that point. So and again, going back to the question about whether or not there was an agreement to verify the audit, that also would toll the interest and might negate the claim entirely. But I want to address the jurisdictional points here, because I think we're skipping ahead some critical questions and going to the merits of the argument, which again, we don't think that there are good merits positions for an entitlement to interest. SCI claims that it's automatic, it's not. But I want to address some of the administrative or jurisdictional points. I do want to finish on their claim that interest never had to be raised again. To rule for SCI Fuels, this court would have to hold that every applicant for a refund has to raise a separate action for interest after the determination of the refund entitlement is complete. Because that's the only way we can get to their point, their claim that they could never address their claim for interest along with the refund claim. All the facts that SCI Fuels
Well, the
raised today,
statute says that if you get a refund, you shall pay interest.
if other
So
conditions are met.
how are they supposed to discern or anticipate that you were going to say, well, we're not going to give you the interest, even in the face of the
In this
statute?
case, it would be simple. The notice of decision that the department issued denied all interest. And so at that point.
Well, it
SCI
denied
Fuels-
everything, so it had to deny all interest.
It did not. It denied part of a refund claim. It didn't grant interest on that claim either. And it denied the claim that subsequently was challenged and denied all interest on that. And subsequently, after that administrative proceeding, there was another final order denying that claim as well. But going back to this issue of having to retry interest claims separately, this would have to be a
So your
mandatory.
argument is they should have persisted with their interest. They said something about interest in their first filing before DOA. They should have persisted in that, and when they were up here, they should have said, and first ECA, you need to tell them that they need to follow this statute and give us interest.
They did not file.
Because we think that the department may not follow this statute. Are courts in the business of telling agencies who haven't not followed a statute that they may not follow in the future, you make sure you follow the statute? I don't see where we have
I think-
jurisdiction to tell you that.
I appreciate that question. I think courts are in the business of adjudicating disputes, and the dispute is what the parties bring to the court. And here, the claim for interest was never brought timely. It was never brought, respectfully, the first petition that SEI Fuels filed did not mention any claim for interest. It was only the amended petition that was filed 10 months after the denial of interest was filed, far beyond the 60-day jurisdictional deadline in section 72011. So I want to address this.
Before you,
Yeah.
you know, what is before us right now is not an action for a tax refund. They didn't file a 21526 action for tax refund. Hey, they didn't give us interest, so we're going to file a second action. Instead, they believe, rightfully or wrongfully, that you have a ministerial duty to pay interest based on the fact that the refund was ordered by the court, and you failed to comply with that duty, and therefore you're subject to an extraordinary writ from this court. So that's not the same as an action for a refund. So I don't see how it is that the statute prevents this action because it requires them to choose between an administrative proceeding and a court proceeding.
It does in two ways. So section 72011 subsection 2 requires a challenge to an assessment or a refunded denial to be brought within 60 days of the denial. That denial was made, again, with respect to the refund, with respect to the interest claim in June of 2020.
The
There was no-
denial wasn't.
The-
In
the-
June of 2020, the
It
denial
was-
of the interest claim. It
Yes.
was when they asked for interest and you said no.
No, there was a denial of interest in the notice of the department's notice of decision. It denied the refund claim and interest. It awarded absolutely zero. And so within 60 days after that point, there was no filing to satisfy section 72011 subsection 2. With respect to subsection 1 of that non-claim statute, I think the language is also unequivocal. Taxpayers have a choice of whether or not they want to dispute a tax assessment or a refund denial, including a denial of tax, penalties, or interest, by either filing an administrative petition or an action within circuit court. The statute is also unequivocal that once a taxpayer selects Chapter 120, it may not file any action in circuit court related to the same subject matter. Now, SEIR is arguing that this is not related to the same subject matter because, well, this is an interest claim and we were discussing a refund matter. But that's not the test. The test is related to the same subject matter. The prohibition is not against filing the identical same claim. Every allegation that we've been hearing today, every single one, stems from allegations that were raised in the prior proceeding and facts stemming from that proceeding. It's absolutely
Suppose
related
you
to
had
the same
just
subject matter.
flat out failed to remit the money that the court said that you owed. Said, no, we're not going to pay the $3 million. Are you saying that they would be powerless to go to circuit court and ask the
Absolutely.
court to file mandamus?
Absolutely
Because
not.
that is a court action and that is inconsistent with the fact that they chose an administrative remedy?
No, Your Honor, absolutely not. In that case, there would have been a timely preservation of the claim for the refund interest, which would have been litigated in the administrative proceeding. It would have been timely addressed by this court, and there was an order from this court that we were bound to follow, of course. So we absolutely did. But with respect to interest, the question was not timely raised in response to the department's notice of decision in June of 2020. It was not litigated, and it could have been. All of the facts, again, stem and relate to that proceeding. It was not appealed when the department denied the claim for a refund and the claim of interest with the final order following the administrative proceeding. The issue was not argued before this court when this court issued specifically a mandate addressing only the refund claim, which was the only issue before this court. SCI did not file a motion for a hearing or request reconsideration to address that issue. There are no cases in 25 years that I could find where a party brought a separate standalone claim for interest as a separate action for a matter that was not decided or on an interest claim that was not decided initially. If we look at any claim identified by appellants here, or any case, excuse me, that addressed post or prejudgment interest claims.
Well, that could just tell us that the department usually follows the statute.
We do, and we did in this case. Again, SEI is making a lot of claims about its entitlement that are simply that are outside of the record, and they're not supported by any evidence or any finding. There was no finding that they're entitled to any interest claim. Again, there's a question about whether or not 213, 255 applied, about whether or not there was an agreement to verify or audit the refund claim.
Who should have made this finding? You know, because this court said you owed the refund, and then there's a statute that says if you get a refund, you're entitled to interest. It seems reasonably straightforward to me.
You're entitled to interest if certain conditions are met. And so what should have happened and what
So
happens...
what conditions were not met?
Again, this is all outside of the record, but there is a dispute about whether or not the refund application to which they peg their interest calculation was filed within the time period in 2/15/26. The refund claim,
Didn't we award the refund?
yes, but the refund.
You know, the fact that an application was not filed would have been a great defense before this court, but y'all didn't make that.
No, because the refund claim did not originate with the refund application. And again, this is all stuff that's outside of the record. It originated with an audit assessment of the taxpayer and a dispute that was raised with respect to the assessment that was filed long before the refund claim was even, or this so-called application was filed. Now, there are additional questions. I think most importantly, whether or not 213-255 applies, as well as whether or not there was an agreement to verify or audit the refund. They will claim that a rule provides that a certain form has to be signed to show that there's an agreement to refund or verify the audit claim. There's no requirement, this is Rule 12-26, there's no requirement that that form is the exclusive way by which an agreement can be established to verify or refund a claim, so I think they're overstating the value of that rule. I think it's also important to note that that Rule 12-26.004 specifically states that upon an application, the department shall determine the amounts owed. So the point is, once the department determined what amounts are owed, that is the point to initiate the dispute, right? There's a proceeding for it. SCI Fuels can choose their forum. They had every opportunity to present all the facts that were allegedly available to them at that point. That's the time that the adjudication should take place. I would also note, with respect to the word shall, I think they overstate and ask it to do work that it really isn't meant to do. The word shall appears in many instances in the Florida statutes. Agencies shall approve grants, shall award licenses, shall reimburse various costs, but those are all subject to statutory criteria. Those all have to be established by the claimant. There's an administrative
Sure, but
process.
there's a difference between saying that you can file an action for something against an agency for an agency to provide you something, and a statute that says the agency shall do something. In other words, it's a burden issue. The burden is on you to pay interest if they receive a refund, whereas the burden is on them to seek a refund.
The burden is on them to seek a refund if they believe the criteria are met, and they have,
And we found that.
not for interest, Your Honor. That was not found.
We found that the refund was due.
Sure, but this is not a situation, again, of an automatic award where interest automatically follows.
Interest
with
shall
the
be
refund.
paid on overpayment of taxes. We found that the taxes were overpayment and they were due a refund.
Well, if I may respond to that, I'm over
You
my
may
time.
briefly conclude, yeah, absolutely. Well, you may answer, and then you may briefly conclude, yes.
Yes, Your Honor. So there are other criteria, and those are being, SCI Fuels overlooks those entirely. Those criteria would have had to have been proven within the administrative proceeding and the administrative form that SCI Fuels chose. Mandamus, Your Honors, is not a vehicle for a party to revive an untimely claim for interest on a tax refund in a court proceeding, wherein it previously chose an administrative proceeding to challenge its refund denial, where it failed to timely raise that interest claim, where it failed to present any evidence or legal argument with respect to that interest claim in the proceeding in the first instance, then during the administrative proceedings and the administrative trial and on appeal. For those reasons and for the reasons mentioned in our brief, Your Honors, we ask that you affirm the judgment below.
Thank you, Mr. Shrimsky.
Counsel, are there any facts under 213, 255 sub 2 that would have to be determined by a court to see whether you're entitled to interest or not?
We believe that there are not. We believe that the refund claim was complete, and this goes, the department's argument ultimately, Judge Winokur, is that there's some sort of distinction between the conditions for the payment of interest and the conditions for the payment of the refund. But as Judge Roberts noted, they're the same thing. 213, 255 says you pay the refund of the tax if the refund claim is complete.
Right, but it's right there in the
It's
statute.
right there.
though. It has these conditions in the statute. I don't know why, but that's what they are. So typically in mandamus, we do not grant mandamus when there are factual findings to be made.
Correct.
So
And if
it's
this court were
important
to
to know whether there are any factual findings.
And we believe there are not, and we believe the department has acknowledged that they're not because they paid 2 refunds here, right? You don't pay the refunds if the refund claims are not complete. This court determined the refund claim was complete when they told the department to issue the refund in this case. The refund claim is complete as a matter of law. Now, if this court were to find that there is a factual dispute, it would be remanded. We would argue it's remanded. Reverse the motion to dismiss and then we could hash out the factual issues if indeed there are
Can you
any.
hash out factual issues in a petition for writ of mandamus?
I hope so. We believe that there are not any factual issues in dispute in this case. Ultimately, it's been decided several times by acts and/or omissions that the provisions of 213.255 have been satisfied in this case. Your Honor, I want to make sure I get this out there. There's a beautiful symmetry in taxation in my world in some respects. We're talking about interest here on refunds, right? But there's also interest on tax deficiencies, right? So when it has an assessment, a taxpayer has interest that accrues on that assessment. The interest follows the assessment.
And penalties, right?
And penalties. When the taxpayer challenges that assessment, interest continues to accrue until it's paid or until this court says the assessment is invalid. The same symmetry happens on refunds. A taxpayer pursues a refund. Interest is due on the refund. Interest follows the refund. If the department wants to challenge the entitlement to the refund, they can do that. Interest continues to accrue.
Why did the interest issue just sort of fall away, as far as I know, and maybe this is not in our record, but why did it just fall away as to the $500,000 that they refunded earlier?
Because under 213.255, if you cut the check within 90 days of a complete refund claim, you don't have to pay interest. Subsection 4 provides that, which brings up another point. Counsel referenced that somehow we agreed that this was under audit under subparagraph 4, and because we agreed to an audit of the refund claim, that there was a tolling of the statute in order to grant interest. But as the department well knows, subparagraph 4 says there needs to be a mutual agreement for an audit, and that mutual agreement by the department's own rule requires an execution of a form, a department's own form, which was not executed in this case. It's not part of the record. No one has alleged it. It was not executed in this case. There was no tolling. There's no agreement here to audit the claim. And even if there were, then again, why did they issue us almost $4 million, despite that fact? Your Honor, SI Fuel respectfully requests that this court reverse the order of the trial court and instruct the lower court to enter writ of mandamus in favor of SCI Fuel. Thank you.
Thank you, Mr. Bowen. Thanks, both of you. That was helpful, and this is the only argument we have, so we are adjourned.
All rise.